Roland Mumford with Mumford.law. What are the advantages of going through an unemployment hearing if you have potential employment discrimination claims and then the reason for the termination is a false pretext? It's an opportunity to do early discovery of the employer's position. At the hearing, you'll be able to get them to state their reasons for the termination under oath and in writing. If the employer gives a false or shifting explanation, you may later use that to show pretext, a key part of proving discrimination. You can compare their testimony at the hearing with what they later say in court or during the EEOC process. Obviously, in discrimination cases, proving that the employer's reason is a cover for unlawful bias is often crucial. At this unemployment hearing, it's a free shot to get their testimony on the record because very often the HR officer or the supervisors or whoever the employer's representative is at the hearing and they don't have that attorney, they're going to be completely caught off guard and not prepared. These hearings are often recorded or transcribed, and decisions may include factual findings. You can preserve the testimony and evidence early on before memories fade or documents are lost. And this can be valuable if you pursue a complaint with the EEOC, state agency, or file a lawsuit. It's also an opportunity for you to present your version of the events. You get a chance to lay out your side of the story, including any evidence of discrimination. This may help show that the employer's reason for firing you was not credible and build your discrimination narrative. Now, sometimes you may not even care about winning the employment hearing because you're just wanting the opportunity to get the other side to present their evidence and their basis for termination on the record to compare to what they may later say during a lawsuit and the discovery process in that matter. Now, it's a credibility battle. If your former employer or their witnesses make statements that are inconsistent with other facts or with later testimony, that could damage their credibility. And this is powerful when you need to undermine their justification in a later proceeding. It may influence future legal proceedings. Even though unemployment decisions don't control discrimination claims, they can be cited in later filings showing inconsistencies or admissions, be used to negotiate settlements, especially if the employer fumbles their story in the hearing, and be leveraged during EEOC mediation or investigation. And then practice tips for later proceedings. The unemployment hearing gives you a preview of your employer's strategy, helping you prepare for a stronger case. You get experience presenting your case and may even test how certain evidence or arguments are received. Things to keep in mind. The standard of proof is lower in unemployment hearings. They're not deciding discrimination, just eligibility. Be careful what you say. You'll be under oath, and inconsistent statements can be used against you later. Get legal advice if possible. Some states allow attorneys or representatives to assist at hearings. And I would be willing to say almost every state allows you to have an attorney. Thank you for your time. Have a great day. Please click like, share, or subscribe.